So I have an update in the Bianchi Maryland assault weapon ban case, which is currently up for Supreme Court review and is setting the stage for a huge rifle ban decision in the Supreme Court. So let's talk about what is happening. But real quick before we jump into this video, if you think these types of bans on so-called assault weapons is clearly unconstitutional and needs to be struck down, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit them using the website linked down below. And thank you again to SDI for sponsoring and supporting this content. As I mentioned in the intro, we're going to be talking about a critical rifle ban case that is now up for Supreme Court review. You may recall that the Second Amendment Foundation recently filed a writ of cert before judgment to the United States Supreme Court in their Maryland assault weapon ban case called Bianchi versus Brown. This now sets the stage for a critical Supreme Court review of a state rifle ban that could have broad-reaching implications for a bunch of other states, including states like Illinois, California, New York, and others. And this all comes on the heels of the Fourth Circuit recently playing a ton of games and taking the Bianchi case en banc, taking it out of the hands of the lower court after 13 months of it sitting stagnant. The Fourth Circuit en banc panel did this to avoid any positive Second Amendment ruling, and that can be found very clearly by the recent oral arguments that were held in front of the Fourth Circuit en banc panel. SAF decided not to wait for the Fourth Circuit en banc panel to sit on this case and, didn't trust that they would do the right thing, so they instead filed a writ of cert before judgment to take this case back up to the Supreme Court immediately for the Supreme Court to strike down this type of rifle ban. And now we also have law enforcement organizations and other organizations filing amicus briefs asking, in fact, for the Supreme Court to also grant the writ of cert before judgment and strike down these rifle bans. Now, for some quick background on this case and why this rifle ban case is so significant. The state of Maryland identifies certain rifles as so-called assault weapons, not my term, but their definition. Maryland bans the sale, transfer, or possession of semi-automatic centerfire rifles with detachable magazines, and then two offending features like a folding stock, a grenade launcher, a flash suppressor, and other types of characteristics as well. This ban was challenged in multiple cases, and it was challenged in a federal district court in Maryland. In this complaint, the plaintiffs had to concede that their Second Amendment claim was in fact foreclosed at the district court level based on a prior Fourth Circuit precedent in a different case called Colby. A prior case, Colby, challenged Maryland's assault weapons ban, and in the Colby case, a district court upheld the Maryland ban using intermediate scrutiny. And on review, the en banc panel in the Fourth Circuit upheld the state's ban, finding that these rifles are outside the protection of the Second Amendment for a critical reason. They found that these types of rifles are useful in military service. And because they're useful in military service, the Fourth Circuit en banc panel said in Colby that they could in fact restrict the possession and use of these types of rifles. This case, Bianchi had to concede that Colby was the controlling precedent, but that it was incorrect and should be reversed. Then this case, Bianchi, eventually made its way back up to Supreme Court back in 2022. And in that case, Bianchi here, the original kind of cert to the Supreme Court, was asking for the Supreme Court to review this issue, review the analysis used in Colby, and ultimately strike down this Maryland rifle ban, in this case, Bianchi. The Supreme Court ultimately ruled in a landmark Second Amendment case. A lot of you guys know what that is, the New York State Rifle and Pistol Association versus Bruin case. And they found, among many things, that the correct way to review Second Amendment cases is to look at the text of the Second Amendment and then analyze it in light of relevant history. And that relevant history dates back to 1791. After issuing that ruling, the Supreme Court issued a GVR, which is a grant, vacate, and remand in this Bianchi case. That means that the Supreme Court granted review, vacated the judgment down below of the Fourth Circuit, and remanded the case back down to the Fourth Circuit for them to reconsider and reanalyze this case Bianchi in light of what they said in Bruin. That reconsideration essentially requires that this case be reheard using text as informed by relevant history and tradition. This case was opened back up, and then oral arguments were heard by a 3-judge panel, and that happened all the way back at the end of 2022. But after those arguments, this case sat dormant for over 13 months, and we heard absolutely nothing from the Fourth Circuit. And then suddenly the Fourth Circuit en banc panel stepped in. That, of course, was not great news, because what that meant is that the Fourth Circuit en banc panel took the case out of the hands of the lower 3-judge panel, and likely that was because they knew that the 3-judge panel there was probably going to issue a favorable or pro 2A decision, and they didn't want that to happen. And so this just further showed that the Fourth Circuit there, the larger panel, the en banc panel, was going to play games. They were not going to adhere to what Bruen said. They were not going to, adhere to the Second Amendment. They were going to try to find in some way that these rifles are still banned. And so it was just not good news. But the awesome team over at the Second Amendment Foundation, SAF, a lot of people I've worked with in the past, Adam Kraut, Bill Sack, Lauren Hill, all of them, they did an amazing job. And then they filed a writ of cert before judgment, asking for the Supreme Court to in fact step in right now and not wait for the Fourth Circuit en banc panel to get this wrong, to sit on this case, to use the wrong analysis again. Instead, the Supreme Court needs to step in now, use the correct analysis, and then also stop all this lower court defiance. Now, in this writ of cert before judgment, the question presented to the Supreme Court for review is very simple. It states that whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with semi-automatic rifles that are in common use for lawful purposes. So the court is simply being asked to finally address whether these types of rifle bans are constitutional or not. And now things are getting even more interesting because you have various groups like the International Law Enforcement Educators and Trainers Association, along with other organizations, which have filed amicus briefs to the Supreme Court in support of the Supreme Court, in fact, granting the writ of cert before judgment. In their brief, they state that the en banc Fourth Circuit in Colby versus Hogan called the AR-15 and other banned semi-automatic rifles exceptionally lethal weapons of war, unsuitable for self-defense, and with a capability for lethality, more wounds, more serious, and more victims, far beyond that of other firearms in general, including other semi-automatic guns. After Bruen, lower courts that have previously upheld gun bans under other rationales have shifted to the Colby theory. For example, the Seventh Circuit declared the rifles are not arms protected by the Second Amendment because they are almost the same as machine guns, exclusively and predominantly useful in military service or reserved to the military. If the claims were true and the rifles were actually super guns useful only for mass slaughter, typical American peace officers would not choose them, nor could they be allowed to use them. They also go on to point out in the brief that the rate of fire of the AR-15 and these similar, semi-automatic rifles is no more than just common handguns. So to claim that these are just so much more lethal because the rate of fire is just not true. They are semi-automatic, just like semi-automatic handguns. And the fact that these are just purely semi-automatic rifles means that no military force across the entire globe uses these types of rifles for military service like the Fourth Circuit is trying to claim. Therefore, the First Circuit, to argue that these are useful military service is incorrect. Finally, in their brief, the organizations walk through the ballistics of a .223 and a .556 round and how it's inferior to many other types of rifle rounds, how ballistically it is not, this catastrophic round. And even some handgun rounds have better ballistics than just a basic .223 or .556. They also debunk a lot of the overstated wounding capabilities that the lower courts point to. And so they use a lot of, ballistic evidence and a lot of just real, evidence to show that these arguments that these are just so dangerous, that they are just hyper dangerous over other rounds and other types of firearms is just simply not true. Now, as I pointed out in my last video, the Fourth Circuit en banc panel has actually held oral arguments in the Bianchi case, while this case is also pending for Supreme Court review. And, there's a lot of points in those oral arguments where you saw some of those judges, use the military use language. They said that the military use test was not overridden by Bruen, that Bruen didn't address Colby directly and didn't override Colby directly, even though it struck down tier-based scrutiny and the use of intermediate scrutiny. A lot of those judges in some way are going to try to, I believe, still keep the military use test, viable and still try to use it in this decision. There was also some back and forth about sending the case back down to the lower courts. And so it just didn't sound like the Fourth Circuit is going to do the right thing. The en banc panel is not going to adhere to what the Supreme Court said in Bruen. There are plenty of judges during those arguments who are outright kind of making fun of the Supreme Court and just saying that the Bruen analysis is unworkable. And so that just signals that the Fourth Circuit en banc panel is not going to do the right thing. And that's why it's even more important for the Supreme Court to grant the writ of cert before judgment, step in now, not only strike down these rifle bans, but also once again strike down the defiance of these lower courts who are not going to follow either the Heller decision or even Bruen. So that's what's currently happening in Bianchi in the Maryland ban. Right now there is still that, writ of cert before judgment, which is pending in front of the Supreme Court. The oral arguments has happened in the four-circuit en banc panel. We're waiting for a decision from the four-circuit en banc panel, and then we're also waiting for some briefs to be filed in the Supreme Court. And so it's going to be interesting to see how this develops. If anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.